Hey guys, and welcome to the weekly docket. Hey guys, good early evening here, and some people popping in early, so let's catch where everybody's coming from. We got a Philadelphia, and just in case that wasn't clear enough, we got somebody else pointing out that it is a beautiful Pennsylvania. You probably will in a second. Getting some feedback here from the director, producer. Ohio and Canada. Awesome. And Virginia, my home state there from Charlottesville. And okay, now she's telling me it's come up, and it finally did pop up something on here. So sorry if that seemed weird. But anyway, it looks like the eastern part of the country and continent is well represented. Let's take a look here first at our old buddy, Daryl Brooks. And hello to Marsha Lynn in Texas, the great state of Texas. And Tina coming out of Florida. So many interesting things in Florida. Man, we had some great experiences there. A lot to see and do. Indiana, we'll be visiting your state during this. Missouri. Yeah, very cool. And Minnesota, often cold there, I'm led to believe. And same thing for Michigan, right? And we're going to hit some cases there soon, I think. Fuquay, nice. Home of Fuquay Gun and Gold, one of the greatest places to buy a firearm in North Carolina. So, good people. Some more New York, Maryland, and New York City, as we're doing a quick census here. Before we get into what's going on with our buddy Daryl, so I'll cover him, and then I'll come back to Houston. Spent a lot of time in Houston, Alabama. Let's do Daryl, and then we'll come back to where everybody is at. So as you know, or probably know, his transcript is finally, I think, done. So what's going on with it? Let's take a look at how to initiate an appeal in a criminal case in Wisconsin. So first, you file a notice of intent to pursue post-conviction relief, and Brooks did that. So that's not an appeal per se, right? That's a notice of intent to pursue post-conviction or post-disposition relief. Then you request a copy for the transcript, and they did that. And then, of course, that took months and months and months, but I think it's in now. Now, after this transcript, you file a notice of appeal or a motion for post-conviction relief with the circuit court within 60 days after the transcript is delivered. So now it's time for the notice of appeal, right? Or some motions action, right? So the party is just getting started for this guy. Don't think that his appeal, should he have one, or a no merit report, is on the near horizon for poor Daryl as he sits in jail, but with clear vision due to the birth control glasses he's been issued by the state. And then once all this finally happens, then the last part is the clock starts ticking for a brief. So the question will be whether the attorney makes some motions at the circuit court level or simply files intent to file a no merit report, or probably gets another extension of time, because if there's one thing you know about the court system, things can get delayed here and there and almost everywhere. So the notice of appeal is yet to come. I didn't see it on the docket yet, but maybe we'll see that, or a no merit thing or something like that soon. So we will find out soon. And thanks to Marsha Lynn for supporting the channel. She is personally responsible for some of the graphics, which I certainly enjoy. It makes it fun to do the channel. Many of you seem to. And then every once in a while, somebody tells me it's terrible that I have an intro. How dare I? I don't want to miss Central Oregon. Spend some time out there, too. In chilly 45 in Seattle. That's interesting because it's kind of that cold here, but we're not going to 26 yet. Again, anywhere close to Mount Rainier is somewhere that I like. Who's paying for the monstrous transcript? Taxpayers in Wisconsin would be the people doing that. 37 in Pennsylvania. It's getting cold here too. Winter is coming, as they say on Game of Thrones. So this is the bad news for Daryl Brooks, and he's a guy who you don't have to feel bad about getting bad news, right? That it's just not going to be over for him soon, and certainly nothing good for him is on the horizon in the legal system. Cold in Connecticut, I doubt that. Our eyes are starting to turn north. We got some planning to do to get back up to the Northeast soon. So where we do want it to be very cold and very snowy. 34 in Minnesota, Michigan, right? Michigan, yes. All right, let's take it down south to South Carolina, where even when it's cold, it's not that cold. And look at some developments on the Murdaugh case. They're really amping this thing to make sure they can create as many miniseries for Netflix scenarios as they possibly can. As you know, Murdaugh's team has accused the clerk of court, Becky Hill, of interfering in the case by talking with the jurors about the case. She denies it. Judge Newman has recused himself from this motion. But in the meantime, her son, who apparently was a director of IT for the county, has been arrested for eavesdropping. So does that tie it into this? Does that just randomly occur while this other stuff is going on? I don't know. It does say that the eavesdropping occurred in July. That's after the case. So I don't know if it's connected or not, but this will make it easier for the writers to generate some more content for the next miniseries about this as they move forward with trying to find things to put on Netflix. Yeah, taxpayers paying, Christina says, taxpayers paying for the transcripts. It's worth keeping that so-and-so locked up. Yeah, he's not coming out. He's not coming out. And I see some airplane symbols. That's always cool. 63 in Northwest Alabama. Doesn't it figure? Sometimes it's good to be in the South. Let's take a look at Richard Allen's case and what is going on with that. We've hit it on some live streams in some great detail. We did a member stream about the original action there, the original jurisdiction of the Supreme Court for this type of thing, but we'll also hit some of that in this. I will try not to get too detailed because Mrs. Southern-in-law, who's sitting in the room with me right now, warns me that if I go down the rabbit hole of technicalities, it's super boring. So she's going to flag me if I'm doing that. This first slide here is a dude who's not there, but it's a different case. And the only point of this is his attorneys moved to disqualify the judge, saying the judge was biased based on past statements. And in a different case with this guy, saying he can't believe that this woman wanted to be in a relationship with this guy who was suspected in the disappearance of his girlfriend. Now he's arrested for that disappearance for murder, and they want the judge thrown out. But the Kentucky Supreme Court looked at that and said, well, we're not going to rule on it because guess what you didn't do? You didn't present the question to the lower court. You didn't ask the judge to recuse himself, so you can't come up here and ask us to do it. So again, it's not like they just look at the merits of these actions. It's very important that you follow the procedure or your action gets thrown out. So that's just an example of that happening. I don't think it's going to happen in this case on the recusal motion, and we'll see why. So what else is going on? Well, Mitchell, what is his name there? We got to make sure I don't say it wrong because I've been reading a lot of names today. Pop up here. His Mitchell, is it Westerman? Yes, Westerman. So he's been arrested. This is the guy who was in Baldwin's office and admittedly took pictures of some of the evidence that Baldwin had laid out on his conference table. And, on one hand, of course, Baldwin is supposed to secure custody of the discovery he has in the case, and he's not supposed to leave that out in any kind of negligent manner. On the other hand, he's trying to work the case and had his war room set up, and this guy took advantage of that. And this is someone who apparently had worked for him before and went into the conference room and took pictures of it and ended up sending it to other people. And I know some people are like, oh, well, other people have leaked things and this, that, and the other. That's also has the same resonance, essentially, if you tell the officer, everyone else was speeding too, right? I mean, you don't just get to do it. The question, of course, is how much blame should Baldwin get for this happening? And I think, maybe a little bit, but on the other hand, this is the guy who did it, and he didn't do it with Baldwin knowing about it. He did it himself. Well, he's been arrested for conversion, which is a little like theft. It's not exactly the same. It's exercising control over someone else's property. It's a pretty broad definition. I don't know if he fully fits under it, but the way they define it, he's got an issue here. And it's a Class A misdemeanor, which is the most serious kind of misdemeanor they have in Indiana, and a potential punishment of up to a year in jail. So he's got a problem there, and which he should. I mean, because he pretty much screwed over everybody in the case, the victims, families. Richard Allen screwed him over because it tipped the scales here in terms of the judge being upset with these lawyers, and this case is in turmoil now. And this was the, quote unquote, final straw that set this off. And it certainly had nothing to do with Rozzi. And the only thing it had to do with Baldwin was Baldwin trusted this guy to be in his office and not take pictures of things and send it to people. and yet he did it. So I don't know his motivation or whatever, but a colossal mistake. The only thing I will say about it is at least he filed his own affidavit saying, yes, I did do it. So he closed the loop on that. And that's helpful, I think, because it reduces the speculation. I've seen some people say that, oh, well, he was, the prosecution put it up to him to sabotage Baldwin. And that doesn't really make any sense because this was Baldwin's friend and prior associate. That'd be a deep Odin reach there to think this was a conspiracy. Not everything is a conspiracy. I don't know why this guy did it, but he couldn't help himself. And he was, he knew about the case, was talking to Baldwin about the case. Baldwin was doing something else in his office and this guy took pictures. That kind of thing can happen. So that's really unfortunate. Yes, conversion. So it's closely associated with theft. Let's see. I think they have it down at the bottom here in paragraph 9. He's committed the act of conversion. So, that could be different things there. You might be live streaming somebody's copyrighted performance. You might be staying in an Airbnb longer than you're supposed to. You're exercising control over somebody's property, even though you're not, trying to take it and get away with it and deprive them of it. So that it's a little different than theft. So I'm looking here on some. What's that?
Did he make money on it?
Mrs. Son-in-law says there's a question there. Did he make money on it? And I'm not aware of that. I think he had an interest in the case and he gave this to somebody. It's possible that he had close relationships with people looking tightly at the case, thought it was okay to share it with these people. But I'm not aware of him getting any kind of money for it. So, and it was Rozzi, by the way, as it mentions in here in paragraph 7, during an interview with attorney Rozzi, he said he didn't authorize this guy to do it. He also believed that Westerman's taking of the photographs constituted theft because he did not believe anyone had authorized him to take the photographs. So Rozzi was right on this, saying this guy ought to be charged for this. And I don't blame him for being that upset about it. So unfortunate situation here. And for this guy, he's been arrested over this. I don't have any doubt that, like everybody else, he wishes whoever actually did this would find their way into prison. But that doesn't excuse everything everybody wants to do. So, all right. So just so you know, so Mrs. Son-in-law sitting in the room right now, she has a microphone, but it's muted unless she points at it to say something. So she is talking to me, but it's like I have a voice in my head, probably, as far as you're concerned. It's often not the only one, but this one's real. So anyway, that's Westerman. Let's look at some other things about this case. Let me get back up here on the main thing. So as I've said, I used this slide from the last week. The real fight is on November 27th. So the responses from the judge are due at the beginning of the week for the material things in this case, which is the disqualification of Rozzi and Baldwin, and also the judge being disqualified herself, removed from the case. That's what they're asking for. So also asking for a speedy trial date. That one, I think, won't happen if they get a new judge, because really that should be up to the judge to do. If Rozzi and Baldwin come in, maybe you come back in, maybe you could put it back on the calendar for January. I just don't know. So to me, that would be maybe overstepping for the Supreme Court to do that. But the first two things are certainly within their power to consider, which is the judge's authority to disqualify these attorneys, and also whether she should stay on the case or not. So, yes, I see the thing about did he make dollars. I wonder if she might be running, the real chat may be running ahead of what I say. All right. What do you have to do to file these writs of mandamus and all that? Because I talked earlier about, like, if you miss one thing, they will just flat throw it out. You're in a technical land when you're up at the Supreme Court. This is not broad pleadings that you just barely get it across and scoot it across the start line. You've got to have everything in it, they say. If you're missing any of these elements, they toss it out. So that's why you see, like I said before, some of the weird things that get said in these that maybe don't sound like normal people's language, or why are you saying this? It's expeditiously made, and extreme hardship and all that. So you can see on the screen, there's the 6 items that have to be alleged in a petition. So they got to set those things out, and you can bet that if you're the respondent, the judge, if you don't think they made one of those 6 out, you got to attack it, because if you can show the higher court they're missing one of these 6 things, then the writ's gone. I think it says that. Yeah, original action petitions that do not include the 6 enumerated items and a statement of precise relief shall be rejected by the Chief Justice or acting Chief Justice. So you got to have those in there. And of course, the counsel knows that they put all that in there. But that's why it reads like it reads sometimes. They want to make sure that the higher court knows, hey, we put everything in here that we need to put in. And it's really important because if you look under that, there's another rule that says in original actions like this writ of mandamus are viewed with disfavor. Okay, you can't use it as a substitute for appeals that are supposed to occur after some kind of dispositive action. Time you disagree with the judge, you don't get to go up to the Supreme Court in the middle of a case and say, force this judge to change their mind. So you have to show they're way out of their lane in one way or the other under the standards that they have there. It's also a condition for the writ, as it was in that Kentucky case that I showed earlier, that you have to ask the lower court to decide on a thing before you go up to the Supreme Court, or you can't tell the Supreme Court the judge won't do what you want or won't correct what you want. That is interesting that in Indiana, you see, they say, except in actions involving a change of venue from the judge. So they call that a change of venue if you want to switch judges. So that's already an exception. And that's why I say the second action, I think, is likely going to get decided on the merits by the Supreme Court in terms of the disqualification and the change of venue. Probably the first one too, but that one's a little hairier because of the motion wasn't made at the trial court level. Yes, an interesting question here. I glance over at the, let me pop this back, change the game here a little bit. The question is, would she talk to me, Mrs. Southern-in-law, if I was a foreman of a jury? Ha! And that is an interesting thing because, of course, when I work on cases, I can't talk to her about it. And it's, I was thinking about that because of this situation with the Maya Kowalski case. But, the theory that could this guy be coming home while his wife is interested in this and them not talk about it? That obviously is possible because sometimes I've represented people that we both know, and I can't tell her any of that. And that's one of the features of the profession, that I don't do as many weird things as I did when I was young, but you hear a lot of weird things and you don't talk to people about it unless it's some other lawyer you're working with. And you get a lot of bizarre experiences in your mind that kind of just stay there. But I don't know. I'm going to tell you that I think that's not always honored, probably. I mean, come on, people have different standards personally than regardless of what they swear an oath to. But I've always tried to take it pretty seriously because of the trust people put in you when they tell you these things, and you can hear some doozies. So, and comment another thing on the chat here about Nicola and this song. Yes. And Mrs. Southern-in-law thought this song was like, it's about flowers and it's in the field and looking at all the great history of Scotland. I'm like, no, this is a song about somebody's angry about some kind of battle. Here you go. I can tell by the expressions on their face and how they're playing it. So, of course, we looked it up and we have started our historical research on Scotland with this basis that Nicola put forward. And, of course, it's ancient because Europeans can hold a grudge and have a long-term memory of past grievances, which is kind of awesome if you think about it. So let's roll forward here. Sorry about all the diversions, but hey, man, the chat's what makes it worthwhile, right? Let's move it on because I've had this thing up here about rules for a long time, and I know that's boring. Let's talk about a little bit, though. Hey, what about Richard Allen's Sixth Amendment right to counsel? What about that? The judge took that away from him at a very fair point, and good to know that that's out there for it. So counsel of choice is essentially your right, to the degree you have it, for retained counsel, not appointed counsel. So that's interesting, isn't it? It's a distinction. So you don't have as much protection if the state is providing counsel for the switching of counsel than if you retain counsel yourself. But even if you retain your own counsel, it's not an unfettered right to be switching lawyers and stuff and say, well, I want to hire my own lawyer. The typical case, okay, that this comes up for is they might be on the eve of trial. It's been delayed, and the person has appointed counsel and they say, well, I want to hire a lawyer now. And that's going to involve a continuance. All the witnesses are assembled and things like that. The judge has some discretion there to maintain the court's docket, consider the interest of other parties and stuff like that. So while you do have a right to go retain your own counsel, if you're abusing it, it's possible that the judge may not honor that. There's also not a right to continuity of counsel. So in the appointed case, if they switch counsel, you can't say, well, they violated my rights sheerly because I don't have continuity of counsel. But that's not the same as saying it's not an interest that the judge ought to weigh. a right is different than the considerations of discretion that the judge has to stay at least within. And oh, look at that. So let me start there. I got running in my mouth about the law, but thanks, Nicola. I say she has provided some memberships to people, so hopefully they'll find that worthwhile, and thank you very much. So anyway, there's no right to continuity of counsel, but we're going to look at a little bit of Indiana law in a moment about this, and I put in all capitals here so I wouldn't forget it. Big move by Allen's attorneys to appear pro se, because what you ought to be detecting in what I'm saying is within the right of counsel, there's a greater protection if you have retained counsel rather than appointed counsel. Okay, not that there's no protection for appointed counsel, but it's higher if it's retained, and higher in Indiana. So here are the appearances by Baldwin and Rozzi where they say, hey, we're coming in pro bono. How about that? And look what he says. Attorney Baldwin enters his appearance as Mr. Allen's privately contracted lawyer. And then Attorney Rozzi enters his appearance as Mr. Allen's privately contracted lawyer. And they're basically saying that they don't want to be off the case, but if they're not going to be the public defenders, then they are entering an appearance pro bono retained by Allen unless and until they're reappointed back on the case. And they make the points here, which is, of course, a good point, which is typically anyway, when the judge interferes with the counsel situation, especially if it's privately retained, it's because the defendant is trying to delay the case in some kind of games tactic thing. Whereas here they're making the point that we're ready to go to trial. If you don't let us take this case to trial, it's going to linger out there for another year, but we're ready to go. So this is the polar opposite of the normal case where you justify limiting the right to counsel because of some kind of game the defendant's playing. This is the opposite of that. So that's interesting to me. Another Scott there. I'm doing this to the Scots the great courtesy of in no way attempting to do their accent. I can't say that I don't, though, when we watch shows on TV and stuff, but it's not any better than when I try to speak Spanish, as Mrs. Southern-in-law doesn't enjoy that either. So I know I'm working on English. It's my second language and my first one. So they call it interference with right to counsel a structural error, and including counsel of choice if it's retained counsel. So it's a pretty serious deal. But they also make the point here, which might be hard to read. But nevertheless, what they're basically saying is what I said, because this is stuff I had in the slides to make sure I didn't forget this, that the judge does have a right to deal with other interests. So if the defendant is trying to game things and stuff like that and switching counsel in the middle of trial and stuff, the judge can put the foot down and say no more of that. So it's not most rights are not absolute in that there are always limits on them. Time, place, and manner for the First Amendment, various things and other rights as well. And this is a big question here. Let me pop this up because this is a question I got. If the Supreme Court were to say, Judge, you're removed off the case, or if the judge were to say, look, I don't feel good because we know she's having medical conditions, I will go ahead and come off of the case. Either way, if she goes off of the case and Rozzi Baldwin are back in, when will the trial start back up? And that just kind of depends, right? So if you got a new judge, that judge needs to assess the docket. That judge has got to come up to speed a little bit, and that judge may have a schedule to deal with. What if that judge has a trial in January or whatever? But it's possible that the thing could be put back on quite speedily. He does have a speedy trial right, so I think they would try to exercise that. And really, what is anybody really waiting on at this point? Let's go. And then Nicholas makes the great point here that Judge Gull has taken sick leave. If that continues, will it be a reason for her to bog out from the case? And I wonder that too. She hasn't done it yet, but that would be a great way to just moot that element of it, right? And just leave it behind. So let either the new judge or the Supreme Court in that case decide whether Rozzi and Baldwin can come in as pro bono guys, privately retained, or be reappointed as public defenders. Just take it off your docket. You just get it out of there. And so I don't know if she's going to do that or not, but that would be interesting. Continuity counsel as part of effective counsel is the comment. It drives me up a wall. People take rights to chip away. Yes, of course, they have said that it's not a right by itself, but I'm making a point that hopefully got out that it doesn't mean that it's not an interest that the judge has to consider. And the reason for this is there was a counsel who had to go into a hospital, had done part of a case this is the case where this came up. The the attorney did as much as they could, and apparently the defendant liked this attorney, but then the attorney had a medical issue, had to go to the hospital for a while, so they appointed another attorney, got like halfway through the trial or whatever, and then attorney A comes back out of the hospital, and the guy wants to switch back to attorney A, and I think the judge said, no, let's just go ahead and finish this with the new attorney that you got, because we're halfway through the trial, and we're not going to stop in the middle of it and start switching attorneys. And so they said there that, that didn't compromise the verdict. So that's a long way from saying it doesn't matter, of course. And like some of the interests that the court says you should consider as sometimes contrary to this right of counsel, the parameters of that are delay of the case. And of course, my point here is this is the opposite, because usually it's the defense, at least where you want to interfere with right of counsel, it's defense seeking the big delay. And here, the big delay is caused by switching the attorneys. They're ready to go. So this is the opposite of when you normally see these kind of cases come up. And thanks, Nicholas, for also I should note that's a super chat or whatever. So thank you very much. That is, I appreciate that. And if you ever want to talk about this stuff, either come on or I come to your side, let me know, and we'll chat about it for sure, because you're definitely a fun guy to listen to and talk with. So let's the American Amendment. Okay, yeah. I saw an American lawyer talk about Australian case, kept talking about the American Amendment. Yeah, it's the old joke is, do they have 4th of July in Great Britain? Oh my God! And I just got the notice from the producer to do not do that. Do not do bad jokes. All right, let's go here. So we're talking a little bit about this. As I say, it generally doesn't apply to appointed counsel. So if you're getting appointed counsel, you don't get to go through the phone book of appointed counsel and pick just the one you want. You're going to get who you get. And if they end up switching this counsel for whatever reason, you don't have as great a right to complain about it as if you were privately retaining counsel. Again, it doesn't mean that this discretion is completely unfettered. And I'll finally get to this case here, because I know we're well into the weeds on the law here. So look down at the bottom here. This is from an Indiana case. The right to counsel choice has been described as an essential component of the Sixth Amendment right to counsel. The right privately to retain counsel of choice derives from a defendant's right to determine the type of defense. Lawyers are not fungible. Often the most important decision a defendant makes in shaping his defense is the selection of an attorney. In situations where a defendant is able to retain counsel privately, the choice of counsel rests in his hands, not in the hands of the state. So to me, while it's maybe not directly in the action here, the fact that Rozzi and Baldwin appeared as privately retained counsel pro bono activates this kind of concern for choice of counsel, in my opinion. And it makes it much more stark that it's not pure discretion of throwing around appointed attorneys because they didn't say, well, we'll come back on this case as long as we can get paid and are appointed again. They said, we're appearing in this case privately retained. And I think that was a big move by them. Certainly potentially a great sacrifice by them and or other members of their firm. And now, sometimes when you see people go to battle over ethics and things like that, it wouldn't surprise me if their partner said, look, we'll cover you on money to some degree, maybe all the way, for the time that you're doing this case, because we back you up on this. That wouldn't surprise me. I don't know if that's happening, but I have certainly seen behind closed doors people put their self-interest into second place at a long shot and to help other people. Let's see. Needing at least 11 months more delay shows that it harms his defense. I can't argue with that. If he's innocent or not guilty or whatever you want to say, you can't repair the fact that this delay is a significant portion of his life, right? This delay, and he's not the one causing it. Especially kicking Rozzi out because Baldwin's office had a picture get leaked out of it. It just seems excessive to me. So that's what I think about that. This sounds like a law that wouldn't change all that much from state to state. Now, are wrong in this assumption? Not really, except for this. The federal standard under the Constitution, that applies as a minimum to every state. Then it gets interpreted by the states, and the states are free to, generally speaking, to add more protections to individuals. They just can't have less. Having said that, this might have been in the member stream. I think I mentioned the Supreme Court takes like 150 cases or something out of like 7,000 petitions. So you have to look at the flavor of how rights are being evaluated in each state to see how the justices there look at it. So it generally ought to be the same, but you still need to look at that state and see how they look at it. Also, their own state constitution may have a greater protection. And now here in this Indiana case that's still on the screen, they're certainly quoting out of U.S. Supreme Court cases and other authority like that. But, you know, if you're going to fight over this, you want to be able to quote, of course, the U.S. Supreme Court in your favor, but you'd like to also be able to quote your own home state Supreme Court, who will be making the decision on this and say, you already said this about this. We already know what you think about this. So I agree that it generally shouldn't change much from state to state, but it's always good to see it dialed in on the state that you're actually litigating in, especially if you're dealing with a constitutional right. So, for example, the Supreme Court may say, well, the trial court has a great deal of discretion, and then in Indiana, they may express how much discretion that means in their state, and the discretion could be slightly different, you know, somewhere else. So the law is very active and alive in this country all the time, federal and state level, with you know, the district courts around the country, the federal circuits only controlling a certain amount of states and things, and the Supreme Court sets to reconcile differences between circuit courts, big constitutional questions, and things like that. I did see that the George Floyd case, that the officer was stabbed, so it's not good, I think. Probably, whatever you think of the case. Oops, let's look ahead. So that's it for Richard Allen at this point, because we will get some more knowledge about this thing next week when we see the judge's response. It's possible that Allen's team will want to file what I call a reply. They call it something different because of the nature of the action they're in. And then the Supreme Court will issue a decision. This is not an appeal. It's not going to take 18 months to get a decision. This is an original action. And so there'll be a decision probably pretty promptly about it. And I'm in North Carolina, for the person asking where I'm at. Raleigh, North Carolina. The other Carolina. And one of the top 2 Carolinas for the people from South Carolina who watch. So here's Chad Doerman. Look how sad this poor guy is. This is a guy that's really sad, but I think it's just for himself. And I'm going to show you some of the concerns he has for his case. And I would have liked to have had a tiny violin playing, but there is no violin small enough for this guy. That physicists working at the Large Collider in Switzerland, they don't even have a theory that operates of a particle so small that it would be on the scale of the violin that would be appropriate for this absolute loser. I don't presume him innocent because he's absolutely guilty, and you know, that's why I wouldn't be appropriate to be on his jury, or his attorney for that matter, because he just shot his children in cold blood. So he's not the kind of guy that I want to give a lot of benefit of the doubt to. Name one of the southern states. Contestant, North Carolina. Yeah. And yes, the guy was he was stabbed in jail. Is it possible for still talking about Richard Allen, for the lawyers to be reinstated and the judge stay on it and proceed? Oh yeah, I mean, that's possible. They could say, well, this disqualification is invalid, so they're back. But not throw the judge off. It's also possible that they say the disqualification is not supported in a record. Go back and make a record on it if you intend to do that. And those are, you know, kind of punts, I think, in those cases. And my feel is they won't punt here. My feel is they'll deal with it. But it's a mandamus situation, so you never know. Why didn't he plead guilty? Would have avoided the death penalty. This dude. Well, Chad Doerman, so he always, of course, still could plead guilty. Okay, so, and I don't know that they said, well, if you plead guilty, we won't go after the death penalty. Remember the Parkland shooter? I think he pled guilty, and then they had the longest, worst freaking hearing for a death penalty ever, one that pretty much talked me out of being in favor of that, and Steve Gosney talked me out of being in favor of the death penalty pretty much. So let's see what some of Doerman's concerns are, so I don't have to, and you don't have to continue to look at this joker. 41 motions filed so far in his case. Now, again, he is facing the death penalty, so his lawyers are doing what they're supposed to do. I don't criticize them at all for what they're doing. He wants to appear in street clothes. He wants to appear without restraints. He wants to exclude crime scene photos from the jury. He wants convicted felons on his jury. He doesn't want the first phase of his trial referred to as the guilt or guilty phase. He wants to have his trial at Burger King where he can have it his way. But while his attorneys are doing what they're supposed to do and filing all these motions, and my instinct would be, why don't I rule from the bench that I'll just go ahead and put one in your head. They don't work that way in the court. And instead, the judge actually is sympathetic to some of these motions, as you can see, at least one of them, because the judge said, I've been advised, and I've so advised counsel, that Mr. Dorman has not been disruptive in any fashion at the county jail, has not caused any problems. He's been in my courtroom twice. He's been very compliant, and that will weigh into the methods of restraint that I'll consider at this point in time. So his good behavior after being placed in jail could get him at least some of what he wants. And let's face it, all he was really interested in was murdering innocent children. If you see the video, the body cam video of right after he did it, as he's sitting there with a rifle, he's telling the police, I'm not going to hurt you or anybody else. So what a trustworthy guy. What a trustworthy guy. Now, about this convicted felons thing, I did look up the law up there, glanced at it pretty quickly to see what the disqualifications are, because it is possible to come back into a jury pool. It just depends on which kind of crime you committed, and you've served out your sentence. So there's some crimes that continue to be disqualifying, and maybe he wants those on there too. If he wants a jury of his peers, he wants 12 people who have served time for murdering innocent children would be his peers in this case. So, yeah, I don't know that and this is a good point here. Of course, no felons on jury. They hate child killers, right? And that's an interesting thing. If you've ever spent time around serious criminals, is their ethics are not, of course, all the same. So, you know, somebody who's stealing property and things like this may very well hate somebody who assaults people, especially in, you know, kind of a sexual way or something like that. Then some of the sexual assaulters might hate murderers. And then some of the murderers and assaulters hate the child people the most. So there's like a hierarchy of hatred there. And so getting felons on your jury might work against you, because they might hate you worse than even a normal person would. So, yeah, it's a shame he gets a defense at all. It kind of is. You know, if we were all seeing and all that, then maybe we wouldn't need to do it. But we do need to have the process for everybody. And even the worst people deserve a fair process. That's how you know that that everyone should have it. So again, his lawyers are doing what they're supposed to do in a death penalty case, because that really ramps things up and file lots of motions and stuff. So I think felons would fry him. Yeah, I don't know that that would really help him there, but an interesting motion to file. My profile of preferred jurors would not be convicted felons. They would be a certain other type of people that I won't get into here, because it might offend somebody. Yes, even people with no morals have a hierarchy of bad people. That is correct, for sure. So, yeah, and the jury should see the crime scene photos, and of course they will. You know, now they may limit how many they show and stuff like that, so it won't be unfairly and unduly prejudicial. There's lots of rules and stuff like that. And Katrina gifting out memberships, thank you. You and Nicola have given a great gift of membership to this channel to many people, and I hope they enjoy it. So I'm always looking for comments on the member side to make sure that there's some value there, because we do get in the weeds there sometimes. So we'll end our search for the world's tiniest particle, which, if we ever found it, the universe's smallest particle would still be larger than the smallest violin needed to be on a par with Chad Doerman, and we'll head off into the sunset for another case. Well, okay, let me put this broadly. Who would I want on a jury? I would look for the kind of people who would think he can't help it because he must have had a mental issue, that care that maybe he got spanked when he was, you know, people that want to let somebody have an easier time on punishment for maybe their background and things like that. And I don't know that felons are going to get you there. You're going to need a certain educational background, ideally, to get 12 people who will look past these three faces that are on the screen here and know that they were murdered in cold blood, and consider this guy as some sympathetic character. Because really, when you mass murder or you serial kill or something like that, there is obviously something mentally wrong with you. You are not right. And if you take that as, therefore, let's start excusing your behavior and giving you lower levels of punishment, then that's what you get. So I look at it this way. I don't care. I don't care if they got spanked. I don't care if their dad yelled at them. I don't care if they got something misfiring upstairs or whatever. That might matter for the death penalty, okay? But this kind of person needs to go away, and just go away forever. And We don't need to spend a lot of resources on that person. We could be planting trees in parks. We could be doing reading books to people. We can do anything more than worry about the very worst people. I'm not saying we have to treat them unnecessarily harshly, but I just don't have sympathy for people to do that. I'm sorry. Then that's the way maybe I got yelled at and I was spanked. So I'm more sympathetic to young children. So I can't help that I don't care about mass murderers. You just have to take me as I am. Was he offered a plea deal? I don't think he was offered a plea deal. I remember the prosecutor talking at the beginning of this case saying he wanted to, he didn't say ride the lightning, but it was essentially along those lines. And I believe this one is Ohio. You know, for a while there, I was putting the states up at the top of these because I got one wrong one time. Well, Nicholas isn't going to pull any punches. Here's his theory here. 12 people with degrees in gender studies from California, and then have your client wear a wig and a dress. Perhaps the most modern trial strategy that could be angled at here. But I don't think he's going to get it. And his angle of trying to get felons probably won't help this joker. The Crumbleys. There's problems here, and this, I put it in here even though I talked about them for a minute last week because it kind of ties, I think, a little bit back to the Allen case. There's this issue here with Jennifer Crumbley's attorney facing potential sanctions because she filed a motion or whatever, and she had in it some things about the son's psychiatric records, and the prosecution is saying two things about that. First of all, you filed things that you knew shouldn't have been filed in public. Secondly, you lied in the pleading. Now, does that sound familiar? Does that sound kind of like what Judge Gold accused the lawyers of doing in the Allen case? She said they lied in the pleadings about the imprisonment, wanted to get him out of prison and put him back in jail, and that they were getting things out in the public that didn't need to be there. But the judge here has said, we'll deal with this, I think, basically after the case is over. We'll deal with it then. So he's not throwing her off the case, but, you know, she has a potential sanction there. Maybe contempt, and I'm not saying she's done anything that deserves that. I think my point just is that this does come up, and it doesn't always result in the lawyers get thrown off the case. That's my point there. How about Bryan Kohberger? I always keep him on here because my appreciation for his judge, but I do want to at least report something he did as a very judge. It'd be cool if his middle initial was J. Judge. All right. What isn't this? Is his first name John or whatever? Maybe it is John Judge, J. Judge the third. So he has made an order about media in the courtroom, and a big fight by the media wanting the cameras in there, and then the defense and even the state saying we don't want them in there. And Judge is no extremist. He looks at all the angles and tries to come up with the best solution and the most reasonable solution that he can, and he does that for the reasons stated below. The court grants Kohberger's motion to remove cameras from the courtroom, still and video operated by the media, but the court will continue to allow the proceedings to be videoed by a court-operated camera system. I think they're even going to put it on YouTube. So that way he would have more direct control over it. He'd warned, of course, the media about what he thought was inappropriate use of the cameras there, and some of that was to deal with the focus on Kohberger, and some of it potentially looking at the defense table, and the defense raising the issue that these things were being used online to make Kohberger look bad. I'm one of the people, I guess, that thinks he doesn't really look particularly bad in court, even though I think he did it. I don't think he looks bad in court. That isn't. But I hear what they're saying. The state says they're worried about vulnerable witnesses and things. So the judge says, we'll let the public watch it, which, by the way, he's under no obligation to do, but we'll do it through the court-operated system. So very, very good. And looking, yeah, first name Judge, last name Judge, middle name Che. Yeah, at least he didn't have the last name Garbage Man, because then if he did love the law, he just wouldn't be able to do it, would it? Judge Garbage. There are, of course, some funny names in the law, but this one's not funny. This one's just appropriate. So he did something, and as usual, it's really hard to quibble with his solution here, I think. All right, let's get into where nobody's murdered or anything like that anymore. Let's get into some cases that have concluded with less than stellar criminal acumen. Something fishy at the Crab Shack. This young gentleman down at the bottom of the screen was wanted for murder, but he also wanted to murder his appetite. So he and some of his friends went out to the Juicy Crab, where Juicy never tasted so good. and they had a fine meal there. But, you know, if you start out young like this guy obviously is, and you're already involved at least in some murder, he's certainly presumed innocent, but you're at least touching the criminal lifestyle. Maybe you can't resist another crime. And so he and his friends run out of the restaurant without paying a dine and dash. Now, the dash part wasn't exquisitely executed because an employee was able to get a picture of the license plate while they were leaving. Still, how do you know who was there? Well, this gentleman left his phone in the booth, okay? And when you touch it and it's locked, the picture on the screen is a selfie of him. So they were able to identify this guy and then pick him up, and now he's captured. So another thing there, if you're trying to lay low, maybe don't have your selfie picture on a phone and then leave it at a place where you're committing a lesser crime that will ultimately lead you to be captured for your larger crime. Crabs shouldn't be juicy. And see, I can believe that. Yeah, well, Mrs. Sutherland, I thought she was about to give me some advice on this, but I don't eat crabs. I'm a crab activist, seafood activist. I don't want to eat these poor creatures. Actually, I'm allergic to some of it, but she does. Would you agree with this comment? It shouldn't be juicy?
I've never had crabs.
Never remember. Then why can't hear you? You've never had them? Okay. I didn't know that. I thought you ate lobster, this and that. What's the difference? They're all stuff that's crawling around. Yeah, no crab murders. So let's move on from this gentleman and look at this one, because this was kind of funny. And you may have seen this one. This was at a nail salon. So if you want to nail the crime, you need to polish your technique, and you're going to need to file this one under disappointment. So this gentleman comes into this nail salon, and it's obviously, if you want to score big, you go to a nail salon, right? Because you're going to get lots of cash there. Is that how that works? And you can see him after he's entered. He's holding up something like it's a gun. It might be a gun. And the customers basically have this attitude of, no, dude, we're all waiting for our nails to get done, so just leave us alone. So he's kind of perplexed by that, and he turns over, and this picture at the bottom toward the guy who's running the place, or at least the cash register, to bother him for money. But that guy has a call to take because the phone's ringing, and he picks up the phone and goes ahead and takes the call. And I see at least some people have seen this video. It is worth watching this video. You can certainly find it easily from this description. So what does this poor guy do when he's trying to conduct this armed robbery, and yet no one's going along with it? So he goes back over, starts looking at the customers again. One of them walked outside calmly. In fact, she just stayed standing right outside the door. As you can see, nobody's, one of them is not looking at him, looking the other way. Somebody's looking at their phone. And he's like, what's a guy got to do to rob people around this town? And he walks out, and he didn't get anything. We did watch this video a little bit before we came in. So there's a couple of dumb criminals to take the edge off of the nasty people that we've been talking about. Yeah, if this guy jumped off the Golden Gate Bridge, he'd probably miss the bay. Yeah. Now, this is totally pathetic. I debated Mr. Southern-in-law about whether this was a dumb criminal or not. Not that he's not dumb, because this is dumb, but on the other hand, he didn't hurt anybody. He just threatened them. And so I give him some credit for that. He didn't go ballistic and actually club anybody or shoot anybody. He was bluffing, and somehow they knew it. I've never been in a nail salon. I don't know what really happens in nail salons. What's going on there? And after watching this guy come in, I've been in some crazy places, Green Beret Sport Parachute Club, lots of cool things in other countries and stuff. But I don't know that I've ever been anywhere where people were so stone cold that when a dude comes in and threatens to shoot them, none of them care. Like, they're not even going to pause doing what they're doing. They're going to continue to take calls, book reservations. They're going to get these nails filed, cut, designed, and all that. So while I don't know what goes on in nail salons, I am sure that these are some hardcore people in them after watching this. So he's one of the dumb criminals of the week. The other one, he was totally ignored, and that was awesome. Oh yeah, the business owner took a call. He's like, "You just hang on a second. What are you going to do? Not book the reservation? You're running a small family-owned business here. You got to keep the customers coming. You can't not answer the phone." This guy didn't come in with some reservation, and I can't see his fingers there. It looks like he's holding a phone in one hand and his gun in the other. And maybe he should have called ahead and gotten a reservation so that he could get this guy's attention when he came in. I don't know. Yeah, what doesn't go on is armed robbery, apparently, in this nail salon. So Anybody got any questions on the cases that we have looked at? I do my own gel nails. I don't even know what that is. I have no idea what that is. Is that cushion? So like if you hit something, I don't know what's going on there with gel nails. Funny choices of places to rob. Yeah. Yeah, that is. Should have handed him a job application. That would scare many of them out for sure. Yeah. But this poor guy was totally flummoxed. And if you watch the video, he just runs out of energy. He comes in waving this thing around at everybody. No one will give him the time of day. He goes back and forth a little bit, and then he stands there looking at him like in this top of this picture, like, is this my life? Is this where I'm at now? I can't even armed rob people and get $1. And then he has to walk out. So maybe he was running short on acetone. Yeah, an angle grinder might be what I need for fingernails as well. And maybe they do that there. Again, these are some hard people, obviously. Again, I don't know what they do in there. It's one of the places I don't go in. This is not how I expected this to go exactly. Yeah, it's not as dumb as robbing a gun store, but this result is really interesting to me. And he did leave. All right, look, if we got any questions, I don't think so, because this is the weekend, and I don't want to hold you guys up for too long. We're always trying to rock this out in less than an hour, which we will do, it appears. And then we'll certainly have some big updates in the Allen case next week, and maybe some of these others too, and on the procedural side. And I appreciate that a lot. This isn't a for-profit channel, so when people make donations, which I appreciate, I try and flow it back in with increased graphics and basically anything I can to give you something better to look at than me on the screen, although I can't convince the better half to come on. She does have a mic. All right, you got to at least say hello before we go. Ready? Go.
Hello, everyone.
All right. So it's real. It's not just me. All right, let's do it then. Let's rock on out of here. And thanks everybody for coming by, and I hope you have a great rest of the weekend. And that's it. Thanks. Bye.